So in the sense that if there was a federal case being built against you, and you had filed a federal trademark, you have a federal document that's been filed that you have sworn to be accurate, that is public information and publicly accessible, that could be used against you as evidence.
Soil to the Oil Media, this is the Cannabis Detector with your host and California cannabis industry expert, Kristen Yoder.
Hello, everybody. Thanks again for joining me. And joining us, I have Barry, the producer and co-homie / representative cannabis consumer, who will be discussing the new segment that will be on every show, This Week's Bullshit. Welcome, Barry.
Hey, Kristen. It's great to be here, as always, hanging out with you. And I'm so excited for this podcast and especially this segment where we're going to focus on This Week in Bullshit. Let's get to it. Tell me about what's happening this week.
Well, there are a couple things, but let's start off with GW Pharmaceuticals' drug Epidiolex and the news that just came out that it will be $32,500 annually to use this medicine.
Holy cow.
Yeah. So, surprised? No, not at all. Is it going to be covered by health insurance? That is yet to be seen.
What is Epidiolex used for, prescribed for, and what is in it? What does it contain?
Okay, so Epidiolex is a cannabidiol oral solution for the treatment of seizures associated with Lennox-Gastaut syndrome or Dravet syndrome in patients 2 years of age or older. And it is the first prescription pharmaceutical formulation of highly purified plant-derived cannabidiol, which is interesting because this is not a synthetic cannabinoid like Marinol or Sativex. This is an actual cannabis-derived drug.
You know, we're seeing CBD in consumer products all over the place. How does this product differ from those?
Well, this one has been accepted by the government. GW is from the UK, and surprisingly, the UK does not. They just now passed something for medical cannabis. We'll see how many people actually get access to it. But what's ironic is that GW Pharmaceutical has been growing cannabis and working on this research for years in the UK. And then they just received approval from the FDA to actually sell it in the U.S., but they've had approval from the FDA to do the research for the drug for a few years. It's just interesting. How did they get approval? Why them? Why not others? But there's a way. You have to go through the FDA process of testing a new drug and doing the research in specific ways to get FDA approval to be able to sell the drug legally. But that doesn't mean that all CBD drugs are now allowed through the FDA. It just means this specific one is.
Does this help in any way pave the way for cannabis in general, changing its schedule with the FDA from, what is it, a Schedule 1 drug right now?
Yeah, so people think that it does, but at the same time, and I've told people before, and we've had these discussions, not me and you, but many people in the industry that, you know, Schedule 1 is a very bad place for research studies and being able to do studies on the medical efficacy of cannabis in a variety of different uses. However, it is because of the Schedule 1 status that the medical cannabis proliferation in all of these states across the country is allowed to happen right now, because the minute it becomes Schedule 2, that means that doctors can start prescribing it, which means pharmaceutical companies will take over the cannabis industry, and that will be the end of mom-and-pop medical cannabis product creators all across the country. So it's good, it's bad. I mean, this is great because the problem with drugs right now, all of these different CBD drugs across the country, is there is no one checking to make sure it actually has CBD in it, or if the CBD that's in it is natural CBD, that it doesn't have additives from it, that it doesn't come from a bad source, which just to let people know, they hear, oh, cannabis CBD is better than CBD from hemp, which is ridiculous because CBD is a molecule, right? So it doesn't matter if it came from cannabis or hemp. And for the record, cannabis and hemp are both cannabis. The only thing that is something to note is that hemp is used in other countries to remediate soil where there has been chemical spills. And in China, they use hemp to remediate soil where there has been radiation and other things. And when you're getting CBD extracted from hemp that has sucked out all of this horrible chemicals from the ground and then you're putting it into the supply chain, that is a problem. That is a big problem. So that is one of the major problems right now. As long as CBD is not being certified and checked through the government, you don't really know what else is in your CBD products.
Certainly sounds like a potential problem because it just sounds like we don't really know what happens to the CBD that is extracted from hemp plants that are used to remediate environmental issues. Exactly. So it's a potential that environmental issue that the plant itself is remediating somehow is passed on through the CBD to a consumer. And there's not a lot of research around that right now that could tell us either way. So it is an issue.
The bullshit of GW Epidiolex and the fact that it's $32,500 a year is that people can't afford that. And when you have an illness and you have a medicine that costs this much money, guess what? People can't afford to use it. That's the bullshit. So they passed it. So we found something that actually works for people and they can't afford it. I can't afford to use CBD. I still use ibuprofen when my back hurts. And I know people that have CBD products, but I don't know if you've looked online at how much it costs to get CBD. It's incredibly expensive.
Do insurance companies pick up the cost of this medication for sufferers at all, for people that are suffering from any of these syndromes? And I think they're mostly very young children, right, that have these issues, correct?
Yes. So that remains to be seen. And I really hope that health insurance will help out with this. I'm not sure, though. I'm reading online, it says Epidiolex is initially expected to cost U.S. patients about $2,500 a month. So it doesn't say whether or not they are actually going to cover it.
So it remains to be seen.
Yeah.
The whole thing sounds eerily reminiscent of the EpiPen situation that came out last year with the exorbitant prices for the EpiPens that we were hearing about online.
The Pharma Bro, yeah.
Yeah, the Pharma Bro, Martin Shkreli.
Yeah, that little troll. Yeah, okay, so we know, guaranteed, that if you get Epidiolex, you are going to get exactly the same product every single time. That is the benefit of it. The minus of it is that it's incredibly cost prohibitive. We don't know if insurance is going to cover it. However, if insurance does choose to cover it, that could be a very good benefit because that means the insurance companies are recognizing the cannabis medicines have a medical value, and maybe in the future they'll cover others.
What is in this medication?
CBD.
That's it?
It's CBD derived from cannabis. It's not synthetic. But yes, it's just a CBD isolate. That's it.
What could this potentially do to the CBD marketplace?
It's on a different level. This was CBD that is friends with the government versus everybody else with CBD products out there. I think that if this is to make CBD rescheduled to Schedule 2, then we're going to see a very tight grip on the CBD market. And at least 80% of the CBD products out there now are going to get shut down because they're not FDA approved. But I don't know. That remains to be seen what the FDA is going to do with it.
What does the consumer need to know then about this news?
I mean, I think they just need to be aware of this is what happens when FDA approval comes in and when pharmaceutical companies take over cannabis is they're not going to be cheap and they're not in it for consumers getting it into their hands. They need to make profit. Especially, let us not forget that GW Pharmaceuticals is a publicly traded company. And that means that at the end of the day, shareholders want profit. That's it. So, this is the future of cannabis medicine right here. when a pharmaceutical company is publicly traded, let's not forget that, they might have made something for sick people, but they still need to profit. That's still going to be their bottom line concern.
This is an issue and some news that's going to have some bearing on the entire industry, and it bears some watching. So we're going to keep our eyes posted and our ears peeled for more on this story as it continues to unfold.
Yeah. So our next topic in this week's Bullshit is about the first patent lawsuit filed by the United Cannabis Corporation against Pure Hemp Collective in the United States District Court of Colorado. And why this is incredibly important is this is the first of many, many lawsuits that are going to be happening. And what happens with this lawsuit is going to have a huge effect on the industry, and more specifically with this company, United Cannabis Corporation. What they have patented is basically any cannabinoid formulation with or without terpenes and flavonoids in an aqueous solution. They hold the patent on it, specifically in MCT oil, which I've got to tell you is practically every tincture, non-alcohol tincture, every vape cartridge, everything in liquid with cannabinoids in it that can fall under this patent. And if they can win against this one company, that means that they can sue tons of companies for this, like tons of them. And I actually found one of the term sheets that they have with another company, and they're charging $5,000 a month for a licensee to be able to use the formulas that they've come up with underneath of their patent. And they have this patent until 2035. And they've said that they're very well aware of many companies using these patented solutions. So it's not good. It's not good, and it's not surprising to anybody.
Did they invent the process?
No, absolutely not. What they did is they hired an incredibly smart patent attorney to go in and start filing patents across the world. This isn't just in America. They have, I believe it's Australia, Jamaica, the U.S., Colombia, several other countries. And, it's pretty crazy how big their reach is multinationally.
So these were generally well understood and kind of common knowledge processes for creating different THC products that are like liquid products or vaporized products. And this company has been pursuing patenting those processes around the world with the intent of protecting that patent and controlling the market that way?
Exactly. A good example of how this patent lawsuit could look for the cannabis industry is to look at the apple industry. And there are red apples, green apples, yellow apples, and these apples are known as the Red Delicious apple or the Jonah Gold apple. Those are patented. Those patents then can be sued. Other people can be sued for trying to say that those apples are of a different name or came from a different place, when they have been patented to protect all the work that those apple breeders went through to create those specific apple varietals. So it's specific. It's the same thing with plants. It's the same thing with roses. We're going to see this with cannabis. Because, cultivators spend years, decades, trying to get the right genetics to give the right attributes. And then just to have someone else come and take it and then rename it as something else, that's why people patent these things. But it can get incredibly predatory. Well, speaking of cannabis, apples, and roses, we have someone very bright and rosy with a big bushy beard named Luke Zimmerman, cannabis IP attorney at law, coming up next after our break.
Great. I can't wait to hear it.
The Cannabis Detector is brought to you commercial and advertisement-free through listener support. This enables us to avoid any real or perceived conflicts of interest and bring you unbiased insight into the California cannabis industry, free from any individual, corporate, or political influence. If you find this podcast informative, entertaining, or valuable in any way, please lend your financial support so we can continue this important work. Visit us on our Patreon page at patreon.com/cannabis to learn about your giving options. On behalf of all the staff here at Soil to the Oil Media, thank you for your support.
Thank you so much for listening to today's episode, which is featuring Luke Zimmerman, attorney at law, and he is our IP attorney for the podcast. And I chose Luke because he has an amazing beard. And to me, if you have a beard, you know more about cannabis than people with not beards. No, I'm just kidding. But no, for real though. Luke is an instructor at Oaksterdam. He is just he's a cannabis lawyer. He's an awesome guy. IP lawyer, let me make that clear. So I met him through my ex-business partner and just thought he was a super smart, super genuine guy. And there are not a lot of super genuine people. So I really enjoyed this interview. And I just want to preface it saying that obviously we recorded it on 7/10, which is why we shouted out 7:10 in the beginning of the episode. Obviously, it is actually right now it's 8:10 that I'm recording this intro, so we're about a month late. However, considering that there was just the first cannabis patent lawsuit filed, this is a very appropriate time for some IP law. So I hope that you enjoy the episode, and please let me know. Let me know what you think. Go to info@cannabispod.com and let me know your thoughts, your recommendations, anything you want to say. I appreciate it. Thank you for listening. Welcome to the Cannabis Detector. I have a fellow Cannabis Detector, Luke Zimmerman, who does IP law up in Oregon, joining me today. Welcome to the show.
Hello, Kristen. Thank you for having me here today. I'm going to do a quick correction already also. I'm actually based out of San Francisco. I just happen to live in Portland because I wanted to make running my business extra difficult.
Yeah, why would you do that? But okay.
Because if you can bring San Francisco money up to Portland, Oregon, you can still make rent.
That makes sense. Totally makes sense. Mm-hmm. Nice.
And I got to say, thank you for having me here on this extra special 710. Shout out to all the extract smokers and concentrate users out there.
Dabbing.
And yeah, I'm really excited to be here. I think there are some really relevant issues for BS that are going on in intellectual property in the cannabis industry right now. And while I'm not going to throw any shade directly, I'm going to give you some cautionary tales about what to look out for when you are managing your intellectual property, and especially when you're picking an attorney to work with, which I encourage you to do.
Yeah, that's like, well, I mean, number one, due diligence. Number two, lawyer up, for sure. But do your due diligence on your lawyer first, for sure.
And I think it's the same thing as picking a doctor, that just make sure, just because someone has a degree doesn't mean they know what they're doing. And unfortunately, from what I have been seeing with my research, there is a lot more of that going on. The whole green rush, as it were. There's been a lot of pivoting from attorneys who are probably really skilled in what they do in other areas. I'm just going to throw that out as praise that may or may not be accurate. But then saying, well, cannabis, it's this new thing. It can't be that hard. I'm just going to do it. And there's a lot of time, money, and liability being created by inaccurate information, and a lot of, especially at the federal level, a lot of filings that I'm seeing going on that I would not be comfortable with my client doing, and two, as an attorney, I would not want my name associated with that filing. So we're going to cover that today, though. And as an overview of what I'd like to talk about, do a quick overview of the different types of intellectual property, focus 2 on trademarks, both the state and federal level, and then 3, do a little bit of IP due diligence overview and just some ideas that you should be thinking about, especially when it comes to licensing agreements, which we're seeing a lot more of in the industry. So yeah.
Oh shit. Okay. I live next to a fire station, so.
Hey, my neighbor is building a fence today, so we can just trade off with
cool.
that. You got sirens, and I've got a power tool going on occasionally. So if you hear background noise, that's...
well, I didn't hear yours. Did you hear mine?
I did hear yours,
Oh,
but
okay.
my neighbor hasn't been working yet since we started the interview, so plenty of time.
Okay, well, I have a question for you. When it comes to IP law, there is copyright, patents, and what else? There's several different kinds, because I always get them confused between, and trademarks. Trademarks, copyright, patent law. Are those separate? Are those all IP?
Those are all types of intellectual property, and you hit what I would call the big three. But that being said, there's also subcategories. And I can't even call them subcategories. There's other types of intellectual property. There's trade secrets, which are actually very important in our industry as well. There's right of persona or right of personality, which is your own. If somebody made a cardboard cutout of you and put it next to a display of joints to help sell their joints and they didn't get your permission, you actually have an ownership interest in who you are.
Is it who you are, or is it your image?
It would be overall who you are.
So, for an example, I dated a producer, and I was such good material for him. He literally wrote a little skit thingy about some, stoner chick with issues, kind of. And right. I felt like, bro, you need to give me money if that goes anywhere, and give me a shout out, since you basically just stole my personality for your own benefit. Is that different than what you're talking about?
A little bit different. Right here, what I'm talking about more is if he was and Kristen endorses this.
Gotcha.
And, okay. Yeah. So if you're making a claim that someone is endorsing it, or if for the sake of selling something, you were using your image or likeness in connection with it, especially on the packaging or an advertisement, that's another area of intellectual property. So, yeah, and I'm going to do a quick plug. I don't know if I can do this, but I'm doing it. For Oaksterdam University, I am one of the founding professors for the intellectual property section. So I actually teach down there about once a month, along with Shabnam Malik and Amanda Conley from Branch & Brand, who are both wonderful attorneys.
Yeah.
But so doing this initial overview of intellectual property is something that I do at least once a month.
Cool, so this will be easy for you.
Yeah, I actually don't even need notes at this point.
Nice.
No, so the first intellectual property subject we'll talk about is copyright, which is artistic expression fixed in a tangible medium. Think about a song, a movie, a book, a sculpture. We're seeing a lot of new media come out of especially Los Angeles, where you are, that will have copyright issues to it. If you saw the TV show Just Jointed, there's a ton of copyright issues that go along with that.
Like what?
The other way, just even recording it. Just the fact that it is a television show, the script that goes to it, all of those things have copyright attached to it. And I'm sure that show has been recorded with the federal government, because you can record copyright material with the federal, and I'm going to get the name of this wrong because I'm on speaking right now. Hold on. I think it's just the Department of Copyright. Copyright registration is with U.S. Copyright Office. Yes, I made that way more difficult than I needed to for being on the spot. One of the novel ways that I'm seeing copyright pop up, because I do have some overlap into the world of glass pipes, is trying to register glass pieces, which if maybe at the end of the show, if we still have time, I'll talk a little bit more about that. But so yeah, copyright for all you artists out there. If you are creating artistic works, or if you're authors or musicians, speak with an attorney, especially if you're at a point where your work is if you're being asked if someone can use your work, or if you've found yourself in a position where your work has been used without your permission, definitely a time to speak with an attorney. Then we'll move on to patents.
Wait. What about podcasts?
Podcasts would that would count for copyright protection.
Interesting. Okay. Continue.
Yeah. Which you actually, if you wanted to be really thorough, you probably would have some papers before you do an interview where you are just asserting that all copyright ownership is owned by you, and that anyone participating in the podcast actually doesn't have an ownership interest in what they're helping you create.
Good to know. Good to know.
Oh, also, as a takeaway, I am not giving any legal advice right now. I am not the attorney for anyone who's listening to this. I do not have an attorney-client relationship, and if you have any questions about intellectual property that are pertinent to yourself, I suggest you consult with an attorney. I'll have my contact information at the end that either, if you want to reach out to me, please feel free to do so, or there's a great list of intellectual property attorneys on the National Cannabis Bar Association website.
I feel like I was just Mirandized, but continue.
Fair enough. We'll consider that an IP Mirandized.
Yes.
So the next area we'll talk about is patents. And patents are registrations for inventions, methods, processes. Think about scientific advancement. There's three different types of patents. There's utility patents, plant patents, and design patents. Design patents would be the patterns on a Louis Vuitton bag. Plant patents, which we're starting to see more interest in the cannabis industry.
Yeah, that's what I'm interested in.
Well, actually, you're probably more interested in utility patent, being honest. It's a broader reach of protection. But plant patents, so it has to be a self-propagating plant, and you're really just protecting the mother plant that the clones or cuttings would be coming out of. I don't have the statistics in front of me, but I was looking at this last night, and I think we're talking in the realm of under 10 plant patents have been granted for cannabis-related patents.
So are people able to look up who owns those plant patents? Because
yes.
What I'm interested in is when Monsanto and Bayer, now that Monsanto is being put away, what's going to happen when, I want to know who's patenting these plants, like who is on top of it, besides our government, right? Don't they have some patents?
They do. They don't have any plant patents, as far as I know.
Oh, that's on cannabinoids, right?
Yes, and that's on synthetic cannabinoids. So for plant patents, GW Farm actually holds a number of them. And then there's, I think it's Bioscience, which I believe is out of Los Angeles. Don't quote me on that. That might be wrong about who owns that. But there's two major players right now who have the majority of plant patents for cannabis, or cannabis-related patents. Yes, all of these are, you can look them up on the USPTO patent database. Utility patents, the patent that you talked about owned by the federal government, which was granted back in 2003, as cannabinoids, as neuroprotectorants and antioxidants, is a utility patent. They're the most broad-reaching. They last 25 years. Most recently, I feel like we saw the ripple effect through the industry because utility plant patent was granted for a cannabis plant. And so the misconception would come in where people are like, oh, what strain? And it's not really strain specific. It would be more of the cultivation aspects of the plant. There was also a highlight that there was a low myrcene content, but high CBD content, which I guess is not normal or is standout unique in plants. So it's 147 pages. I made it through about 40, and let me tell you, if you don't have a botany degree, a lot of that, there are words there. Beyond mind-numbing, I'm just like, I really am not qualified to fully interpret what this information means. So,
but do you think they make it that confusing and difficult so that people cannot do something similar to it or copy them or jack their information?
You need that detail. If you want a patent to be enforceable, the more detail you can have in the patent, the better. And this is why, in order to write patents, you really need to pass the patent bar. It's a small pool of attorneys nationwide that have passed the patent bar. But in order to sit for the patent bar, you need a Bachelor of Science in a limited amount of degrees. So you could get, engineering would qualify, chemistry would qualify, botany would qualify. But if you have a botany background and your approach to write a patent for a new lighting system, that might not be a great fit for your skill set, even though you understand the technical aspect of how to write the patent. So you really want to find, if you're going to register a patent or you're pursuing an innovation, you want to find an attorney who has a background that they can understand the detail of what you're trying to patent, especially when it comes to plants. And there is a whole lot of misunderstanding about how the nuts and bolts of plants and those details are where the protection really is created. So yeah, especially if anyone listening is going to pursue an issue with patents, I strongly encourage you to speak with an attorney, and there is time requirements about when you can register the patent. So if you've already made a product and put it in the stream of commerce, I would reach out to an attorney today. I do not write patents. That's not. I practice what's considered soft IP or soft intellectual property, which is mainly copyright, trademark, trade secret, and then licensing agreements.
The juicy stuff.
So we're now on to trademarks, and that is by and far the largest area of intellectual property that I'm seeing develop in the cannabis industry right now.
Yeah.
Trademarks, because everybody is saying, how do you make the brand? Well, I want a brand. I want to brand this. How do I do a cross-branding? And trademarks are great because they actually are a really good vehicle for having interstate issues. Even though you're not taking your cannabis interstate, because that would be federally illegal, you are able to write licensing agreements that moves your trademarks across state lines. So you can have multi-state development through the vehicle of licensing agreements for your trademarks.
Okay, wait. So if you have a brand in California and you don't get trademarks in other states, but
right.
You go to sell you license your brand in other states, what happens if you don't have that trademark? Does that mean that anyone could just jack your brand and then you're not protected?
That has happened, yeah, and actually that dovetails nicely. We are going to cover some BS, especially when we hit the due diligence part of that exact issue. So with trademarks, there are state-level trademarks. Every state has a trademark office that you can register with. The lifespan of those trademarks are usually 5 years. Some states they're less. What you also have to remember is some states will not allow for cannabis goods and services to be registered as a trademark because it would be legal activity. That's the issue that is going on with federal trademarks right now. You're in violation of the Controlled Substance Act. California started accepting cannabis trademarks for the first time ever, January 2nd, 2018 at 9 a.m. I'm proud to say I was first in line to file at the counter. And
I remember.
Yep, 99% certain. I registered the first cannabis trademark in the history of California.
Yeah, cheers. OG status.
I played that out in my head that when I'm 70 and I'm smoking a joint in a rocking chair, I want to be able to look at young people and be like, in my day, I filed this. It's great.
You remember that brand? I filed that trademark.
I have that trademark framed in my home office. And there's actually a funny story that I haven't shared this on a major publication yet, but for the clients that I went down and filed on their behalf in person, there was a counter-filing fee per application, and then a certification fee. And the total cost for all that, this was the first payment received by the California Secretary of State for trademark applications. Guess what the number was?
$420.
It was $420.
What?
I'll send you a picture of the receipt. I have that in the.
It's a sign.
That's what I just started laughing. The counter person started laughing, and we kind of looked at each other like, "Okay, well, I guess it's game on."
Wow, that's so awesome. You know what? Funnily enough, my LLC got completed or whatever by the state on 420, so my company seal says 420 on it. It's so exciting.
I just, it's those little things in life that, I have faith. There's
you're on the right road when you hit a 420,
I totally agree.
Yeah.
So, okay, back to the state and federal issues.
Yeah.
So going into the BS of what I'm seeing, especially at the federal level, So I use some software to monitor my clients' trademark applications and the work that I'm doing. And one of the options for the software is I can easily search through the descriptions of goods and services for the trademark by a word, right? And so when you file a trademark, you have to pick the category or class. There's 45 classes that you're going to register in. And then you have to have a description of goods and services. Now, at the federal level, we already covered, you can't actually get trademark protection on cannabis goods or cannabis services that directly touch the plant because that's a violation of the Controlled Substances Act, which I think most people are pretty familiar with, or the CSA. So another aspect about filing a federal trademark is you have to, at the end, state that there's a complete accuracy in filing. I testify and swear under penalty of perjury or penalty of fine that all information contained in the document is accurate, right? So you wouldn't want to lie. So if we know that you can't have a registration for cannabis goods and services, and you know that part of filing the paperwork is swearing that everything is truthful, what you probably wouldn't want to do is lie or file a trademark application saying that you're actually selling cannabis or cannabis products or engaged in cannabis services. And this brings me to what this search tool for my program can do really well is so I can just, in the section that says goods and services, search for a word, I can search for cannabis. And pulling up a bunch of recently filed trademark applications, I'll just read some of the descriptions to you. And I'm not going to read you the name of the trademark because I don't want to throw any attorneys under the bus because I don't think that's public shaming is not a...
We're not here for that.
Yeah, trying to do that. But okay, so one of the descriptions is Class 33, which is wine and spirits, which already is not the right class to file in, but it's for vaporizer cartridges containing cannabis extract, vaporizers containing cannabis extract, cannabis flowers, cannabis concentrates, cannabis pre-rolls, cannabis edibles, cannabis flowers, cannabis tinctures, topical creams, ointments containing cannabis, tinctures containing cannabis. This application was already filed in the wrong classes, but also in the affirmative that this trademark is being used in connection with selling cannabis and all sorts of cannabis products. So on its face, and this was filed December 7th, there's no way this application will be granted.
The CannaBS Detector is brought to you commercial and advertisement free through continuing listener support. Please visit our Patreon page at patreon.com/CannaBS to make a recurring contribution today and help us to keep bringing you unbiased insight into the California cannabis industry.
And not only that, it's like when people send 10 pounds of cannabis to the wrong address and then the cops are like, hey, anyone who lost their cannabis, give us a call and come pick it up. It's like, why would you give the federal government the name of your company, your trademark or whatever, stating that this is what you do when it's federally illegal anyways?
Exactly. And so through this, I can... as soon as you file a federal trademark, it is forever recorded on the federal database. So I can go to your mailing address, I can go to the owner of the trademark, all of this. So in the sense that if there was a federal case being built against you, and you had filed a federal trademark, you have a federal document that's been filed that you have sworn to be accurate, that is public information and publicly accessible, that could be used against you as evidence. Nice. So but to think then that this application I'm looking at, I think a fair range for federal filing is, between $1,500 and $2,500. That seems to be the range that a lot of attorneys are charging. So this attorney took money from a client to essentially file a document that will never be approved, could be used as evidence against them in a case, and in order for them to say, well, actually, that's not accurate, then they committed perjury in filing the document. That's some BS.
Does this put shade on the lawyer, too? Is this like, okay, this lawyer has now submitted multiple, wrongly classified, stupid patents for, federally illegal companies. Do lawyers ever get in trouble for that?
Could be. And so what this would speak to is either a level of competence that because I've also seen a number of attorneys be like, trademarks, they're not that hard. This is pretty easy to do, which there's a lot to trademark work. And there's a lot to figure out with the ins and outs, especially related to cannabis. The accountability of that, you could potentially say that maybe they weren't competent, which is a standard of ethical care that we owe to our clients. So maybe there's something there. Yeah. More so, I would just look at least from ethically how I practice law, I would have, one, never done the filing. Two, I would not accept money for that work. And mind you, I'm not just honing in on this application. There is a lot of applications that look like this right now, which is really unfortunate because the backlog, normally, we'll say 2 years ago, it was taking about 6 months to have a federal trademark application reviewed. Now it's about 8 or 9 months, and I think in part, especially if they're cannabis related, in part because there's so many applications like this. And these applications will not be granted.
Well, I would think it'd be easy to be like, no. Okay, next, no.
There is a no, but there is a format, and there has to be a response done based on legal principles. So you get either an outright denial, or you get an office action with a chance for rebuttal. These most likely will just be outright denials. And I've actually seen some attorneys who have tried to fight them, which is essentially just giving a slow pitch opportunity for the federal government then to respond, or the USPTO to respond and saying, no, here's our policy. We don't grant trademarks on X, Y, and Z basis because they violate the Controlled Substance Act. So finding an attorney who has an understanding of how these issues work for the procedure, because, there's other trademarks that you can file, which are for ancillary goods and services, which will be registered. And there's some for services that you can even use the word cannabis in the description of services, and you still are federally compliant. You don't have to lie to the government. There's no inaccuracy about what your registration is. And those are the attorneys you want to work with, because they can get you the bang for your buck.
Yeah. And not get the feds on your ass.
Well, and I don't know if I've seen any direct investigation based off of trademark filings, but it is lingering.
Well, it's pretty early in the game, right? And you're not going to know while they're investigating until they act.
This is true. This is not to say that it could not. I'm from the theoretical. This is a liability that I would not want to create for my business, let alone pay someone to do the work to create the liability for me. That's very counterproductive for what you want.
Yeah.
Another issue that I'm seeing that I don't really... So there are a lot of lifestyle brands being created right now in cannabis, which I think is really exciting because they're really going to run the gambit of, they touch a lot of products. The branding for it's going to be really fun. Now, the problem that I'm seeing for some of these are, as I said, there's 45 different classes that you can register trademarks in. I have seen some people say, well, I have a federally registered trademark. I clearly am good to go on my trademark protection. And for pulling up some of the registrations, there are usually in Class 25. And Class 25 is for apparel. If the nature of your business is you are making apparel that's branded with the trademark, that's fine and dandy. But if the reality is you don't actually create a lot of garments, you're not really creating a clothing line, you just filed this because some attorney said, hey, that's the easy class to file in, I consider that really low-hanging fruit that's probably not applicable to your business. And So you file, one of the benefits of registering at the federal level is if someone else tries to register a trademark that is similar to your trademark, it will be blocked if you have already registered your trademark. Where I mentioned office actions, you'll just get a response from the USPTO that says, no, there's a confusing similarity between an existing trademark registration. Unless you can argue around it, we're just going to deny your application. So that's what you're trying to do from a protective standpoint of registering trademarks. Now, if you're registering in apparel, and in order to get this response of being blocked, it has to be confusingly similar, and the trademark has to be being used in the same stream of commerce that it might confuse consumers. So if you're only in apparel, that really doesn't have a large overlap onto cannabis or cannabis goods and services. So I don't really know the value of the protection going forward. I think it offers something, especially if you have a logo, but I don't think it's really what people are looking for, and I don't think there's really enough explanation being provided to clients that maybe this could be done better. So that's another issue of BS that I'm seeing. And this will tie back into licensing agreements when we get there.
Yeah. So when I'm thinking of like my only knowledge really with cannabis and trademarks on a state-to-state level, and the lawsuit was with Gorilla Glue
right.
when they were sued by Gorilla Glue Corp. And I learned a lot from talking to those guys, because what it was is they basically have licensing agreements where if you're selling Gorilla Glue number 4, but now it's GG strains, GG4, if you're selling that and you are not licensed under them, they can actually sue you for using their license or for using their brand or whatever. But
their trademark, right?
Their trademark, but only if they have licensing in that state. So they've gone to every state that they work in, they will make sure to have a trademark for that state. So right. If they didn't, then, because in cannabis, like, people make names up all the time. It is so right. annoying. And it's like, if you don't trademark your strain, then could people just be like, oh yeah, it's Gorilla Glue number 4 in my state, because nobody actually has a trademark on it.
Yes, and actually, you're touching on an issue that we're going to be hearing more about probably in the next 3 to 4 years. And I've been doing a lot of research on this actually in the last week. And I'm on the fence if I'm going to start doing this or not, but really we should not be saying the word strain. From a horticultural... It's a cultivar.
Yeah.
And so one of the issues, if you want to do some fascinating research, look into cultivars related to apples and cultivars related to roses, and trademarks. Because if you have something, a trademark operates as a point of origin indicator for a goods or service. It does not operate as a name. If you're using it as a name, you are invalidating your trademark. So if I said, oh, that's a piece of Kleenex, it's actually a piece of tissue paper. At one point, Kleenex was what you would call a fanciful trademark. But because it became synonymous with the product, it actually became generic. It no longer indicated that the paper tissue was coming from the Kleenex company. It was now just Kleenex is paper tissue. They became synonymous. We have a huge problem with that with strain names in the cannabis industry. And really, so if we're going to do a correlative between the apple or the rose community, like Pink Ladies or
Honey Crisp or something.
Honey Crisp. Right. So Honey Crisp is the cultivar. Honey Crunch is the trademark that Honey Crisp is sold under. You cannot enforce trademark protection for the name of a cultivar. Okay, you cannot. It's not operating actually as a trademark. We haven't seen this challenged yet in the cannabis industry, but I believe it's on the horizon. Really, what we need to be doing is formally registering cultivars. And so, if you had we'll say you created a strain, right? And you call it Cannabis Yonder, right? Yoder. Cannabis Yoder, right?
I like Yonder better, but yeah.
Okay. Well, we'll call it, how about this? We'll call it Cannabis Yoder, right? That's the cultivar, but now we're selling it under the trademark Yonder. That would be an appropriate way to be applying trademarks to cannabis strains. You can't just use the cultivar and try to own the cultivar name exclusively. That is going to cause a lot of problems on the horizon. I don't think enough people are speaking about this. I think there's a lot of licensing agreements that are being drafted right now that are probably not going to be enforceable, or when they end up in a litigation sense, someone is going to say, of course, well, my strain is blank, and I own it, I made it, I called it this, and you just invalidated your trademark right there, even if you have registration.
So in the end, my understanding is a cultivar refers to the chemotaxonomy aspect of the plant, meaning its cannabinoid and terpene profiles specifically, that certain type of terpene profile that you find, that is the cultivar. That's the difference between that and another cultivar. It's not the name. It's actually the chemical aspect of it, right?
So if you think about it simplistically, because there's cultivars in all different types of plants, a cultivar is a plant that's been cultivated for specific attributes. And that is the idea, versus a varietal, which I believe a varietal is a plant that's naturally found occurring in the wild.
Gotcha.
So we have lots of cultivars. We don't have any formal recording or database, really, that these are being well organized. I know that the Genome Project is supposed to be doing good work. I only know a little bit about it.
Phylos or something, yeah.
Thank you. There's actually a group that if anyone has a lot of deep pockets and want to step up and doing something innovative, there's a group, and I just got an email from them, hold on, out of Belgium, Cultivar, that is an international horticultural society. It is the ISHS, International Society for Horticultural Science, that they are a volunteer group that helps maintain and organize cultivar names internationally. The names don't give a legal binding effect or a legal right to the naming, but it's for an organizational purpose. This group, it has like a lot of sub-societies, so there's a lot of orchid societies and rose societies and fruit societies that would just be focused, probably like one society is just focused on orchids. Cannabis needs that. Cannabis needs a group of people to say, okay, we're not trying to exclusively own these names. We're just doing the organization of it to see what names have been used and to check to see if there's an availability of certain names. Downside of this is you have to be self-funded, petition to be included. But I think at some point in the future, this is going to occur. So if there's anybody who's very entrepreneurial out there and has a bunch of money and time, and you're not focused on building your business right now, this could be a project that maybe you consider doing.
I wonder if the strain hunters work on something like this. I mean, that's the thing. Like, everyone calls everything OG, or, cookies or whatever. Like, there's so much bullshit out there that, it's like companies that are going by effect-based names because they're like, oh, strain names, like who can trust them or whatever.
Right.
In that sense, is it important to trademark on these things so that they actually have some standard that you can hold the cultivar to in the first place?
How you have an identifiable cultivar in the United States is getting a plant patent.
Okay, so like nobody. Nobody has that.
Yeah, and that's why I'm saying we're going to see a lot more of this emerge. I think there's some strategies that could be pursued with trademarks, and I think there's a few creative ideas that I'm looking into currently. So I would advise, this is another and it's not a plug for me, but anyone who's working on this, seek an attorney who understands these concepts. That if you start talking to an attorney and you're mentioning some of the things we just discussed and they're looking at you like they have no idea what you're talking about, but they want to file a trademark for you, I would
walk away.
Yeah, that's one of those you might be throwing money away.
Yeah.
So, yeah, that's another issue of BS. I think that is a hot button topic, especially as people develop their brands and are developing this concept of what is the intellectual property that I actually own, that we're going to see a lot more of in the next few years.
Interesting. So. Cool. Yeah. Okay. So then it's important for companies to get trademark for any state that they're going to be operating in.
Yes, and actually trademark protection. So, I mean, we were looking at the very narrow with strain specific or cultivar specific in this last part of the conversation. But broadly speaking, you want to get trademarks for if you have retail services, if you have a dispensary, you want to get a trademark for that. If you sell a branded product of topical cream, you want to have a trademark for that. You can even get a trademark on cannabis as a whole. It's just not as easily done on the individual cultivar, if that makes sense.
And what happens if you don't? What if you don't have a trademark?
So if you're using the trademark, you have what's called common right or common law protection, which innately just by the using it in commerce, you have some level of protection. You get to say, maybe I don't get exclusivity for owning this, but I do have an ownership interest in using this. It is very hard to prevent other people from using that name if you do not do a registration. So right now, as I said, California is starting to accept these. We're starting to see them fill in a little bit. I've already seen a few conflicts occur, and you have what's considered like the superior and the subordinate user, and the superior user might be the first in time, subordinate is second in time. Generally, the superior user gets the right to continue using the mark, but with California and how registration works, if the subordinate user or the later to use user files first and registers the trademark, they actually can have superior right in many cases to the superior user. There's not really a good invalidation process either for challenging those applications outside of a litigation situation, which can be very expensive very quickly. So, yeah, there is a lot.
What's an example of that?
If I filed a trademark, I'm up in Mendocino, and I have been using Panda as a trademark, right? And I'm using it on my cannabis and my Panda. Great. Somebody out of San Diego now within the last 6 months just got their license granted, and they have a Panda. They're using the trademark also, and they filed the trademark registration, and I don't, and I haven't. So what can happen then is they can end up having the right to use it throughout the entire state of California, and I would only be able to use the trademark in the limited geographic region that I have been using it for my period of time. They wouldn't necessarily have the ability to shut down my operation or stop me from using the trademark, but they would have the ability to stop me from expanding my use of the trademark.
Gotcha. Okay.
Yeah.
So all the brands, when I was working on Edible Company, it was like trademark every single brand, every product that came out. It was like immediately turn that in and get that trademarked so that no one else can use it.
And that, if you're going to be thorough about it, and actually the real thoroughness would be before you even make the product or you provide the service under the trademark, you should do a clearance search to have an understanding if someone else is using the mark in commerce, because there was a extraction company or an oil company up in Oregon that I saw that they didn't do this, and by the time they had already purchased advertising material and packaging to the tune of a couple, tens of thousands of dollars, they realized that there's already existing federal application that had been granted for the identical mark for a tobacco company out of Colorado. And that's where there are no trademark police, so that doesn't mean immediately someone's knocking on your door. Maybe 3 years into your operation, someone's saying, well, hey, actually, we have a problem with this. You just popped up on our radar. And really that 3-year period, especially because of Instagram, if somebody is adequately policing their trademark, it happens a lot quicker. Instagram is a great way to figure out if you're overlapping with somebody else's trademark just by searching through hashtags.
Oh, smart. That's smart.
Yeah, well, and it can be used against you, too, depending on I've seen a number of people come in and say, well, I was contacted because of my post on Instagram, and apparently there's a problem.
Gotcha. Yeah, I remember back in the day, like way back in the day, there was a company that they did edibles where they did Hashies instead of Hershey's, and Reefer's peanut butter cups instead of Reese's, but they looked exactly like a Hershey's bar and Reese's, and they totally got sued. They were shut down ASAP.
You're touching on something that is much more just direct trademark infringement.
Which is just like stupid, dumb, hello, duh. But
that is, like I made a reference before of low-hanging trademark fruit. That is basically picking up rotting fruit off the ground and thinking that it's a good idea. And being like, oh, I'm going to run with this. Because, and I use this example in my Oaksham class, and I actually used that case. It was out of Seattle, I believe. You basically are picking intellectual property that you already know exists, trying to create a parody-like or something comical where now it's novel and new and yours, which is completely inaccurate. And any of this idea of parody, you're really applying the concept of it wrong. You're using products, especially in this case, that would be identifiable to children just based on the color and the packaging or the trade dress, that if they get into, you're going to be damaging the child, you're going to damage your business, and then you damage the cannabis industry or culture as a whole. Because you create the boogeyman effect of, everyone has tainted Halloween candy all of a sudden.
I think the company was tainted, actually. I'm pretty sure that was, but I'm pretty sure that was the name of the company, was tainted.
I can't speak to that, but there's a thick level of irony if that actually is accurate. So that's...
Be creative, people. It's the cannabis industry. Smoke something and come up with something creative.
Be creative, work with a creative agency or design agency, but especially don't pick anything that looks appealing to children. Don't pick anything right now that could possibly, if you put it in a room, granted, people are going to say everything looks appealing to kids, but if it's something that really, I hear this one occasionally, and I don't hear it as much as I used to, but if your concept is, I want to be the Willy Wonka of the edible world, you're so far off base for what you should be doing that it's, don't catch yourself up in that. Because that's some BS. What else are we talking about today? We were talking about...
we want to talk about IP licensing deals? Licensing agreements, right?
So, and this ties in with due diligence actually at the same time, because one of the big underlying, and we've talked about this actually in passing in a few different ways, but it's what do you own? Who owns it? And then especially after you own it, what is the value of it and what's the enforceability of it? And so there are licensing agreements that are being passed around right now where there are really bold claims of people saying, well, I've been doing this for 20 years, so I clearly own this, and I need, whatever royalty percentage in order for you to use it. Now, you got to do your due diligence. One, ask them to make sure that you get to see the documents, that this has been recorded, and they really do have an ownership interest attached to this intellectual property. Two, do an honest valuation of what that intellectual property is worth. And then three, make sure that it's actually enforceable. If you're going to sign on to the contract and you're taking on the ability to use this other person's intellectual property, make sure that's something that's really adding value to your business. So I'll use an example of some licensing that I've seen where I was like, that's kind of suspect. There's a lot of celebrities who are trying to get into the cannabis industry now, and a I won't say most of them, but there are a number of them who do not want to put in any skin in the game outside of, hey, you get to use a cardboard cutout of myself. And so where we'll do the checklist, okay, does the person own the IP? Yeah, they do. The value of it, that is where it becomes really debatable for me when I've seen some of this, is just because there's fame in one regard, that doesn't necessarily overlap onto like incentivizing sales in the cannabis industry. So I think doing your due diligence of like, what does this really fit into my building my business, or is this something that I'm just excited because I was hit up by somebody who's famous? So that's just one example. Another aspect about licensing agreements that you want to make sure, don't do licensing agreements on your own. Don't draft them on your own. There's definitely certain legal terms that need to be included in the document, or you will, even if you've registered your trademark, you will invalidate your trademark and have an unenforceable licensing agreement. And then on the other end of the spectrum, if you write too detailed of a licensing agreement that's too restrictive on how your license or your trademark is being used, you can actually end up writing a de facto franchise agreement, which, if that does end up in a litigation sense and is asserted by the other side that really what you gave them was a franchise, not a licensing agreement, if that can be found in a court of law, you just violated some federal securities issues or federal franchise issues, because there's a duty to report and there's disclosure obligations if you're working with franchises. So this is something that really is detailed, focused. Once again, find an attorney who has worked with licensing agreements, ideally has worked with licensing agreements relating to cannabis. I can't stress that enough.
Well, what are the repercussions of not being on top of that?
Worst case scenario, potentially invalidating a trademark that you've built your business around, which would be really hard. Or what about the idea of getting into it where you're really trying to rely on it, then our other side says, you know what, we don't really want to pay you anymore, and we believe that maybe we have an ownership interest in this trademark just because we've done some use of it. And finding that your initial agreement is invalidated and you lost your trademark, and potentially the other side has the right to use the trademark also now. Or it's just not enforceable, so really anybody could use the trademark. So, yeah, there's a lot of room to mess this up.
Well, there's going to be a lot of lawsuits coming soon.
Oh, guaranteed.
I mean, why work hard when you could just sue people that are doing stupid things, really, you know?
Yeah, but I see it as that if I'm working hard, and then you find yourself, because this is the other one, and this is out of my wheelhouse, but we're seeing a lot of cannabis breakups right now. You know, a lot of big partnerships and LLCs are dissolving. You find yourself in a situation where you've partnered up with somebody that you don't agree with, or they're causing problems, and you're breaking up unless you really have, and I'm using this in the licensing agreement sense, unless you really have things dialed in, the idea of the breakup getting messy is pretty realistic. And if you end up losing the right to your trademark, or it just kind of becomes void, like that's seriously going to hamper your... Right, exactly.
Yeah.
So, I think it's one, there is going to be a lot of litigation, but you can take care of a lot of these issues if you work with a good attorney, and you just do a lot of planning in advance. That's really intellectual. I stress this with people. Intellectual property works best when you're laying a good foundation and you have it planned at the beginning. If you find yourself in a crisis situation and you have to work backwards, it doesn't work very well.
So it's kind of like a prenup
and think about that more in the licensing agreement sense, not just in the recording intellectual property. Recording intellectual property is like, I don't know, getting your high school diploma, we'll say, you know. The prenup sense would be the licensing agreement, where you just want a clear understanding of all parties involved. And actually, if you're going to even take it a step farther, if you're doing your business formation and you have your writing your articles of incorporation, you want to have an understanding of, if there is a breakup, who owns the IP. That's a term that is oftentimes overlooked in, I said articles, this should be in your operating agreement. So if that isn't assessed, that can be really problematic if you come to a point where you're dissolving the business.
Yeah, I mean, business partnerships are like marriage without the love because it's a financial thing, right?
That's it.
So
Right,
it's
exactly.
like, yeah, dude, prenup all the way. No one ever starts off their business partnership thinking that it's going to go south. But in this industry, that's a major likelihood. It happens a lot.
And I mean, I think if you've been in this industry for even just a short amount of time, you've heard a story of at least one set of partners where they're like, wow, we were old friends. And then, I mean, and I've found that it's usually when the money starts coming in, people get really stupid. And that's where it gets like, I did more work. I actually own this, you know.
Yeah. Greed does things to people, for sure.
It totally does. I was just watching Arrested Development, and the season where they're working on this app, and his roommate is like, well, I put up the initial $3, and you put up the second $5,000, so clearly I have a superior ownership interest because I did the first round of funding. You know, shit like that is going, I mean,
it happens.
As sadly comical as it is, stuff like this is going on. And I think, you know, I believe that intellectual property attorneys in the cannabis industry were probably like the third wave of attorneys that had a demand. You know, first wave was criminal defense, and then business formation. Intellectual property attorneys kind of came after that. And now we're working into like labor compliance, and really the big ones are going to be litigation. And that's, I think, the future of California right now for the next few years.
Oh, totally. Yeah, I did a podcast episode about class action lawsuits, specifically talking about Brass Knuckles and the lawsuit against them saying that they didn't have pesticides in their product and then it tested that they did, or saying that it was this potency but it wasn't. And, I mean, that's a whole other... Obviously, that's a whole other episode, but I mean... A whole
other episode, and that's a whole other area of law in many cases, too.
Yeah,
you're talking about really a narrow... That's down to product liability. And
that's
there's going to be a lot of that, because if I remember my law school torts class correctly, liability attaches to every point during the stream of commerce. So it's not just the producer, but it's every retailer that sold it as well. And arguably, if it went through a distributor, potentially they shared liability as well. So
exactly, it's a big mess.
Right, that's the traditional lawyering, like legal issues that are now being overlapped on the cannabis industry.
Oh, I saw an advertisement for CLE accredited cannabis class action lawsuit courses now that are teaching lawyers how to go find cases.
Yeah.
It's not hard, that's for sure.
I did not attend that. I know a few attorneys who did, and they said that it really painted a picture that was pretty damning towards the cannabis industry.
It's going to be pretty factual, you mean?
No, well, I think they still had a lot of the boogeyman components about what it was, and they also had the, money grows on trees. So every person you're going to sue clearly has millions of dollars behind them.
Little did they know.
So it was uninformed from that sense, but it did paint a picture that there are a lot of potential defendants, and that's pretty accurate, because this is a fledgling industry. There is a lot of misunderstanding about compliance, and there's a lot of misunderstanding about just general business obligations. Yeah. And so that's,
a lot of cut corners. And when it starts to affect the consumers, when it comes to their health, or, when it comes to the quality, I mean, dude, seriously, I would totally class action lawsuit some people. Like, there are so many bad companies out there that really need to get their ass handed to them, and I'm just like, why not? I mean, it's really not hard to prove that they're full of shit. Like, it's actually very easy. You know?
in order, and once again,
not a lawyer. I mean, you're not giving law advice.
Not giving law advice,
Yeah.
and from my civil procedure course, which was, but once again, years ago, the qualifications for a class action suit in California, I think you have to find a decent number of people in order to bring a class action suit. I think we're going to see more just smaller lawsuits occur. I'm really of the belief that in the next 2 years we're going to see a wave of trademark litigation at the state level. Just because people are finally registering their names and staking their claim. So
can there be trademark lawsuits in states where trademarks are not allowed?
Interesting question. I think if you set up your trademark protection in a very creative and methodical manner, especially because you're probably going to be relying more on federal trademarks at that point. Yeah, I think you can, but you have to do the front work or the laying the solid foundation in order to have any sort of claim. And I only see a handful of companies doing that right now.
Yeah.
So. Yeah.
Well, it sounds like you've definitely got enough business, in the future.
I feel very lucky for being at this point in history, because when I launched my law firm, looking at LinkedIn, it says 4 years and 8 months ago. I remember I had just taken classes at Oaksterdam, and I had met some wonderful attorneys who had been fighting for the cannabis industry and cannabis rights and medical patients for a long time. And I said, who's doing intellectual property and related to the cannabis industry? And they said, well, there's no demand for it. And I was like, really? I'm pretty sure there's going to be demand for this. And I was looking around on Google and was able to find like 6 law firms on the West Coast that I identified as doing at least a little bit, but none of them were really focused on it. And I knew, I was like, there is no way that this industry can develop without having a massive component of reliance on intellectual property. And then I realized that the state, up until, as I said, January 6th of this year, did not allow any cannabis-related trademarks to be registered because they strictly followed the federal guidelines. And I was like, as soon as that shifts, the floodgates are open, man. Like, this is on like Donkey Kong.
Yeah.
And we're just hitting that period. So I feel very lucky to be in this place in the moment of time. I'm also of the belief, and we're seeing some of this. We have a hampered ability because we're in the United States, but the idea of an international cannabis brand and international cannabis trademarks, that's real. That's going on.
Canada is real.
Exactly. I mean, so you can, much like how I said, you can search for patents on the USPTO database. You can also search for trademarks on a search engine called TESS. But if you want to go like really high level, there's a group called the World Intellectual Property Organization, or WIPO. And WIPO has a database that collects the registrations of every country that it's a member. I think most of them have their trademark registrations linked up to the WIPO database. So incredibly powerful search engine. But I gave a presentation last year in Prague, and I was preparing for it, and I started doing research of how trademark registration was developing around the world. And in the scope, I think I started in 2010, and it's like every year thousands of trademarks are being registered around the world. And so in some countries, this isn't disparaging, this is positive, so I feel confident saying this. Bedrocan, you want to do some interesting research, Bedrocan. I mean, they have a U.S. trademark registration at the federal level. They have a Canadian trademark registration. They have an Israeli trademark. They have They have Dutch, but technically it's a region of three countries. But yeah, so they're all over the place. There's a few other. I can't say those names. Yeah. There are some others that are. I think the cannabis trademark that I saw that had the most registrations was like 20 trademark registrations internationally. Maybe it was 25. But that trend is just going to continue, and that's going to keep developing. So yeah, as I said, feeling fortunate for being in this place and time in history, because this is just starting to really open up. And we still obviously have a massive barrier with the federal government and the inability to register at the federal level, because if we could register federal trademarks at the federal level, or cannabis trademarks at the federal level, you can actually then access the WIPO database and WIPO registration a lot easier. But your federal trademark office is really the gateway to the international realm, and we have a massive restriction with that. So other countries are developing a lot quicker.
Okay, wait. So then does that mean that like a California company that goes to Israel, could they not have, I mean, they could still have a trademark in Israel, right?
Oh, yeah. There's a lot of the, I shouldn't say a lot of it, some of the deeper pocket players in the U.S. industry that are U.S.-based companies have trademarks around the world already. And I've only seen a handful of these, but the ones that have done it have done it prolifically and systematically. And that is going to become much more of the trend.
Do you need to be operating in other countries to trademark? Okay.
You do.
You can't just, shoot trademarks everywhere, just in case.
Some countries probably allow registration without use, but this then gets to the tune where you should be working with a trademark attorney in those countries.
Got it.
So, yeah, that's the other thing. If you find some attorney that says they can do the world for you outside of registering through the Madrid Protocol, which really isn't accessible because of the nature of our federal restrictions, but if you find any attorney who says they can do all of that without the assistance of counsel in other countries, that's another probably keep your money in your pocket type situation. Oh, yeah, I think that's the case for any lawyer who says they can do it all. Run. Because that's not possible, dude. It's not possible. No, and I actually want to use that as an opportunity to say, because I've seen some larger law firms make claims that, don't work with solo practitioners because they can't do everything. A good solo practitioner knows what they can do. I'm a solo practitioner. And actually, back when we were talking about trademarks, some of the trademark applications that I was talking about that were glaringly a problem did come from larger law firms. So just because there's a large national law firm, that does not mean that the quality of work is going to be spectacular. I think you just have to do the research and talk to the attorney and really ask them what they know about what they're doing.
It's like you wouldn't go to a general practitioner doctor to get breast enhancement surgery, right? It's like you go to the specialist.
Yes, I wouldn't anyhow, but yes, I understand. Yes, I think I get what you're
I don't know why that came to me. I watched Botched. I watched Botched last night. Okay, that was it. So.
Gotcha. And it was a scarring event. No, see, okay, look at it. It was a joke on a joke on a joke. Okay. But yeah, I will do another plug. I feel like most of the attorneys that are listed on the National Cannabis Bar Association really have taken the time and the extra steps to understand the legal practice in relationship to the cannabis industry in a level where it's not just hey, I've been practicing law for 15 years. I'm also going to do cannabis now, so I'm just going to cut my teeth and figure this out. Yeah. So if you need a default and you're like, man, I just can't find who do I work with? The National Cannabis Bar Association has a database of attorneys that is a really good place to start.
Nice. Yeah, you definitely want to have a good source in the first place.
Oh, completely.
Awesome. So. Well, I think that, is there anything else you want to talk about? Because I feel like we really hit all the bases.
We did. And so just as a quick reminder, this was a quick and dirty on everything.
Yeah.
Like everything we discussed has an immense more level of detail that goes into it, and that's why finding representation that's a good fit is so important to developing your business and protecting your intellectual property. I am proud to say in my practice, I have had a number of clients that have been with me. I'm 4 years and 8 months in, and I've had a number of clients that have been with me for 3 years, because it only gets more complex as this moves forward, and especially getting to the point now where doing licensing agreements is becoming more of a reality, or finding a investor from Canada that now wants to bring your brand to another country. It's more and more real. So my advice, the takeaway, and it's not just a shameless plug for myself, but find an attorney that you can work with, that you can trust, who is going to take the time to pay attention to the business that you're working on, who understands the nature of the cannabis industry, and will work with you. That it's really worth it, because working backwards and trying to protect things after the fact is very complicated, if not impossible. Yeah,
especially in a changing regulatory framework continuously, state and federal.
Oh, yeah, completely.
Totally. Cool. Well, thank you so much for coming on and hipping people to the knowledge they need to save them from hopefully not getting fucked over somehow.
Well, yeah, thank you, Kristen, for having me again. Happy 7/10 to everyone.
Yes.
If you want to find me or contact me, my email is lukeszimmerman@gmail, or you can look up cannabislaw.law. We'll take you to my website.
Creative.
I know, I got really lucky with that.
Did you trademark that?
No, it's just so. And this is other We'll do another one really quick. URLs do not give you trademark protection. I find so many people who are like, yeah, but I own the URL. That does not equate to trademark protection.
Yeah.
I just was really fortunate that there was a new URL opened up specifically for attorneys, that you have to be, you get verified. In order to get your URL, they verify that you're an attorney. And I looked, and no one had taken cannabislaw.law. And I was like, yes, please. Let's do that.
Cool.
$75 a year? Okay.
Hell yeah. Nice.
So, but thank you for having me on the show. I hope to come back in the future, and we'll point out some more BS and hopefully teach some more people about intellectual property and what's going on in the industry.
For sure. I'll have you on when the lawsuits start happening, and we can do a play-by-play.
Wonderful. Okay.
Awesome.
Well,
all right. Have a good 7/10. Talk to you later.
Peace.
Bye.
The Cannabis Detector is produced by Soil to the Oil Media.